we've got a great couple panel discussions today. DLA has partnered up with Concilio to put this on. It may take us a second to get set up here, but I'll introduce our panelists while we're doing that. Because before I do that, I want to talk about sort of a general theme that I think you'll hear today through both panels, and it's a reason that all of us, each of us, should be very proud to be part of the organizations we are with in Texas, because Texas really has been, continues to be, and will be a true leader in the nation in business and legal developments. You can see that by all the corporate relocations that we're having throughout Texas, certainly in North Texas as well, and a lot of the legal reforms that we're seeing here that make the environment here very business friendly. And I think we're so well poised just to continue this trend and going to continue to be a leader in the nation and in the world. And so it's an exciting time to be a lawyer, to be part of the organizations that we're part of. And thank you so much to the ACC for letting us have an opportunity to highlight that. So specifically today, this first panel, we're going to talk more on the litigation side, and on the we've got Judge Whitehill from the inaugural judge from the business courts. So we're going to talk a little bit about the new business courts and what that means for our state, and talk about some other legal developments that relate to that as well, that have impacted the legal environment here. But we do have a great panel, as I mentioned. We've got Andrew Hansbrough, the Vice President and Associate General Counsel at Public Storage. He oversees all the litigation, regulatory, and operational matters for that large public entity, and he's got a great perspective on what's going on in Texas, specifically vis-a-vis the nation as well here. As I mentioned, we've got Judge Whitehill, who is the inaugural judge here in North Texas for the business courts. Judge Whitehill was a justice for the Fifth Court of Appeals before graciously accepting the honor of being the judge on the business courts, and was a partner at Gardier, now Foley, before then. We have Patty Wise there, who leads Concilio's Lawyers on Demand unit and helps clients nationwide build flexible teams across all industries. And last but not least, Angela Mayu, who is the senior litigation attorney at Southwest Airlines, who has over a decade of experience managing complex litigation and regulatory matters across various industries for Southwest. So thank you all for being here. We want this to be as interactive and informative as possible, so I definitely encourage anyone to ask questions at any time. We may save a little time at the end for questions, but you don't need to wait till the end. If you've got specifics, just shout them out. But we're going to start with Judge Whitehill. Judge, can you just provide some background on, so we're all sort of starting from the same place, on the business courts, the creation, the coverage, and the purpose of them?
Yeah, so as you all know, Texas is a very dynamic, growing, vibrant, economic place to do business. All the activity that happens in Texas as the 8th largest economy in the world. The GDP in Texas is larger than Russia, Italy, South Korea, and many other large industrialized countries. The GDP in the Dallas-Fort Worth area is larger than Poland. The GDP in the Gulf Coast area around Houston is larger than Argentina. We have the most in the agriculture area, most farm and ranch land in America, leading in many areas of production. For example, you may not know that Texas is the nation's largest producer of watermelons. The Port of Houston is the largest port in America in terms of waterborne freight. Port of Corpus Christi, not to be ignored, is the 3rd largest energy port in the country, 5th largest energy port in America. All of this economic activity produces disputes. So one of the main reasons to have the Texas Business Court is to provide a new forum so that businesses like you all have a new and different way to have your disputes handled. We are a vital part of the state's economic development engine. critical to bringing new enterprises like Y'all Street to Texas is creating a court that provides the predictability, consistency, expertise, hopefully, that you all need to have your disputes handled effectively and efficiently. Our mission on the business court generally, and mine in particular, is to completely create a new and innovative way that we handle commercial litigation disputes. I want you to think about what we do as a marriage or combination, if you will, of federal fast-track litigation under the state rules with a lot of the informality and flexibility and adaptability that you might find in arbitration. Handling dockets. In Texas, in large urban areas, each of the district judges will have at least 2,000 cases on his or her docket. They do not have the time and the resources to pay attention to the large resource hog type cases that we have in the business court. So a large part of our mission is to create another alternative so that your cases have the resources available to do with that. For example, we're one court, and I want to make that's a very important part of our mission is for people to understand we are one court. We happen to have 10 judges, but we are to speak with one voice to create a body of jurisprudence that the businesses can study, rely on, and use to predict for their transactions and dispute resolutions. Consistent with that is the simultaneous creation of the 15th Court of Appeals, which is a specialized, if you will, intermediate appellate court in Texas. It is a statewide appellate court, but it has very, very, very narrow subject matter jurisdiction. One of its areas of jurisdiction is all disputes that will arise through the business court will go to the 15th Court of Appeals. Again, that's part of the process and desire to create a uniform, consistent, predictable body of law. Texas otherwise has 14 courts of appeals, get a lot of different opinions. We're going to try to solve that.
So how has the court's been in existence for about a year? Can you tell us a little bit about how that first year has been, what kind of cases you're seeing, and how the process?
It's been fantastic. I think we are meeting and far exceeding the expectations for what people had for the business court in terms of the number of cases that have been filed so far. As of yesterday, we've had a total of 189 cases filed. That doesn't sound like a big number, but when you realize the involvement, management involvement that we have in the cases, our responsibility to write opinions on dispositive motions and things like that, we are working really, really hard, and we're doing groundbreaking things. You all tell me how we have been received in the legal community. Only positive things, right? Tell me. But no, we have been a startup enterprise. We've had to find space. We've had to find employees. We've had to find furniture. We've had to get our systems up and running. And all of it has worked really, really well. I think the demand for what we are providing in terms of an alternative forum to resolve your disputes has been well received, and we're operating well.
One of the things, Judge, that you mentioned when we were talking about this event was some of the unique things that the court is doing in terms of efficiency and the timeline. I think, would you mind expanding on that or talking to our audience?
I would love to expand upon it. It's usually an hour presentation, so I won't do that. But for example, in my chamber, I want to create an environment where people understand they have business problems. My life has been about business since I first stepped foot on the University of Texas in 1975 as a finance major, briefly a banker at Republic National Bank, and doing commercial litigation for 40-something years ever since. I want to sit around a table with people. I don't believe in benches, except in jury trials where we kind of have to do the dog and pony show. Because benches are a communication barrier. I don't believe in robes, because robes are communication barriers. I like to sit around a table with business professionals and their clients and say, look, y'all are business people. You have a business problem. We're going to approach this in a business-like way. I'm going to help you resolve your problems. That may be through a trial at the end of the day. It may be through dispositive motions, or it may be other things that I can do along the way to help you do that. I require the clients to attend the original scheduling conference that we have 30 days after the first defendant appears. Sort of a novel thing. But I tell them, this is your case. It's not your lawyer's case. You need to see what's going on. If you don't already know the party on the opposite side, you need to meet them. You need to see the other side. You need to see how they react. You need to meet the opposing counsel, see how they interact. You need to see your own lawyers in action and how they're doing, because your job as a client is to identify, assess, quantify, and manage risk. All litigation is about doing those things. You need to do that, and I encourage them to be part of every appearance that we have in court so that they're involved in that. I hate discovery disputes, okay? You all hate discovery disputes unless you're a partner in a big firm, but maybe that's different. As a business court, we have adopted a local rule that says before you can file a discovery motion, you have to exchange letters with us, no more than 700 pages, trying to give us a brief description of what your issue is. I'm a little bit more aggressive than my colleagues on that, because in my initial planning conference, I tell people, we don't do discovery disputes in this chamber. I can't prevent you from filing one, and you have the right to do that, but I can do a lot of things to help make that unnecessary. For example, before we even get to the letter writing stage, even before we get to and you've all seen the lengthy email debates that go on back and forth, even before we get to that stage, I say, what you're going to do when you first see that there's a potential dispute, you're going to call my court manager, Susan. She's fantastic. Susan's going to be your best friend. And you're going to say, Ms. Bowen, is Judge Whitehill available? If I am, I'll get on the phone. More likely, we'll set up a video conference either that day or the next day, and we'll talk about it. And I can't make a ruling because there's not a pending motion, but my experience over the years is that when lawyers have to explain things to a judge, the issues tend to get more simple. They tend to want to pay attention to what the judge is saying. If I had wood, I'd knock on it. My colleagues have been inundated with discovery motions. In a little over a year that we've been in operation now, I haven't had one. And I think that's because of what we are doing on the very front end to establish the environment where we're going to do things very efficient, very economically. The legislature has put a lot of pressure on us to get our cases resolved roughly in 18 months after they're filed. I'm a little bit more aggressive than that. I want all of our cases, jury trial, non-jury trials, set for trial roughly a year after that first planning conference, which will happen again 30 days after the first defendant appears. And that has been very successful. I have not had any pushback on that. And what that does is it forces people to focus on the critical issues. I know from over 40 years of doing commercial litigation, every case, and I've been part of trying cases involving billions of dollars or hundreds of millions of dollars, they all come down to a dozen to 2 dozen critical documents. They're all going to come down to no more than 4 critical witnesses, maybe a lot more witnesses, but it's really going to come down to roughly 4, and it's going to come down to 2 or 3 critical legal issues at most. So in the planning conference, we encourage people, listen, let's identify those things up front and focus our attention on those things. So one of the things that we have done, Texas doesn't have a specific rule on this, so I've sort of created a rule. We'll see how long I get away with it. Under Rule Procedure 166 GNP for pretrial conferences or status conferences, I say, okay, I'm going to call a status conference, pretrial conference, but I've been looking at the file, and this looks like a purely legal question, so I want you to brief it in 10 days, and I want you to respond in 10 days, and I'll tell you what the answer is. We can do that on the front end. I can tell you what a contract means. That's my job. I've been doing it for 40-something years. I can tell you whether it's ambiguous or unambiguous, or if it's unambiguous, what I think it means. Let's identify that. Let's get that resolved up front, and that will save a lot of time, effort, and money. That has been so successful that in cases, the lawyers have said, hey, Judge, we kind of think, we agree this is a legal question, we want you to decide it, and here's our proposed schedule. I said, great. I'm in the decision-making business. I'm happy to do that. One of the innovative things that I do is I require a status conference every other month leading up to the trial, because I know that if something is on the calendar and people have to be prepared for it and deal with it, they will, because some people, most lawyers don't want to look like they're uninvolved, detached, or don't care about their case, or they're being, some of them might be irrational, but they don't want to appear irrational. And so when there's something on the calendar that has to be dealt with, they do. And that's been hugely successful. They're off the record. We're doing them by video conference so almost exclusively now. And it's 5 to 15 minutes, but it's, hey, how's the case going? Is there any issues bubbling up that may get in the way of having our trial? Your young lawyers are going to love this, because what happens in a big case is there's a lot of slack in the beginning, right? Somebody files a petition or a complaint, and the defendant, once they're aware of it, wants an extra 30 days to respond or otherwise answer, and then everybody's going back and forth. We're cutting the slack out by having a very tight, in the federal courts they call it a rocket docket. I call it the hypersonic docket. And so we're doing that. God, I've been talking too long, but as you can tell, this is one of my favorite topics. And yes, sir.
Just as a random question, are judges selected round robin? Is it you file and ask for a specific judge in the business court? How's that work?
Okay, so there are 11 divisions, if you will, within the business court. 5 of them are operational, and they're around the major urban areas: Dallas, Houston, Austin, San Antonio, and Fort Worth, and surrounding counties. I have 7 counties in the first division, and we're the first division, I like to think, because we're the best. But the venue rules are exactly the same for us as you would find in any state district court. So if the venue facts would place venue, say, in Dallas County, then your case is going to be assigned to the business judge in the first division. There are 2 of us. There are 2 judges in each division right now. And so it's randomly assigned, as randomly as you can get between 2 judges. And an interesting fact, we just learned a couple of months ago, we always believed that the assignment was random. We learned that Tyler Tech, which runs the e-filing system, actually had an algorithm where they were trying to balance workloads and things like that. So now all of your filings happen in one central docket with the clerk in Austin, Beverly Crumley. She's fantastic. Everything we do is electronic. When the case comes in, they assign it to the appropriate division, and there's a coin toss as whether it goes to me or Judge Baressa. So you may see some cases that get back-to-back with me or back-to-back with her. That's just the result of a coin toss. We want to make sure people are not trying to game the system by watching where cases get assigned.
Thank you. Yeah.
Sure.
The other thing that I know, I just need to say that the judges get to talk as long as they want. Right?
No.
But it's,
And Mark, before you do that, I want to take an opportunity to ask the judge a question.
Please.
I was
Absolutely.
a lurker in your conversation with the Dallas Bar Association on Tuesday, and there are a number of things that I thought were really interesting. But for the in-house lawyers, all of us are really curious about how's the business court going to be different. And one of the things that you talked about was when the court gives an opinion or renders judgment, you wouldn't expect just a one-line motion denied. Can you talk a little bit about the court's approach, or at least your approach, to written opinions?
No, absolutely. So as a former appellate judge, I love writing opinions. As an appellate lawyer, I love opinions. One of the most frustrating things about the state system in Texas is there is a disincentive for judges to explain their answer, right? Because the Court of Appeals is going to affirm them for any possible way that they can. I was always frustrated with that and thought that was unfair. I also thought it gave the judges an excuse to kind of put their finger in the air and guess what the answer would be. And that did not necessarily produce the best results. When you have to write an opinion, when you have to explain yourself, it forces you to actually think about how this is going to happen. And what I learned on the Court of Appeals is even when you have a conference and you think you know what the answer is, it's not until you actually start writing the opinion that you may change your mind and come up with a different result. So the legislature said, in order to create this consistent, predictable body of law, similar to what you see in Delaware. Some people think we're competing with Delaware. I think we're just going to be the best, and things will happen anyway. But so the legislature said for dispositive motions, if a party requests an opinion, we are required to give an opinion. If our decision involves a question that is of importance to the state jurisprudence, we're required to write an opinion. I was fortunate very early on. So a little bit of history. We opened our doors September 1, 2024. And by statute, we could only take cases that were filed on or after September 1, 2024. There were a lot of people that wanted to be in the business court and thought that they could come in because the law said the law takes effect on this, whatever. We said no. But I had a massive partnership dispute that had been percolating through the state court for several years. The lawyers really wanted to be in the business court, so they agreed to do a Rule 11 agreement. Y'all familiar with the Rule 11 agreements? It's tolling all statute of limitations, stopping discovery, and saying, Judge, we're refiling in your court, in the business court, and here are all the summary judgment motions. We're resubmitting them. We want you to decide them. Well, this was a massive partnership dispute involving an oil and gas partnership, and it raised interesting, really novel questions of what is the nature of so-called fiduciary duties under the Texas Business Organization Code, and how do contractarian principles apply in that context. The Supreme Court had never really written on this. We've been through 3 versions of statutory changes since the common law, the intermediate appellate courts, and I give them grace because when you're on an intermediate appellate court, you're drinking out of a fire hose, right? In the 6 years I was on the 5th court, I published over 600 substantive opinions. But this was an opportunity. The Supreme Court hasn't written on it. Obviously, the 15th Court hasn't written on it. I don't have to pay attention to anybody else. And I knew that everybody was going to pay attention to this summary judgment opinion because it was going to be the first one out of the business court. I know that business lawyers and business professionals around the country are paying attention to the Texas Business Court. Is it really going to fulfill its promise of being different, providing a different service, or is it just going to be another state district court? And I'm bound to determine that no, we're going to be different. Actually, I think we can provide better service than your federal judge. Not that they're not highly qualified people and they don't have highly qualified staff, but all we do is business disputes. They have to deal with criminal cases that have priority. They have to deal with diversity cases and whatever issues those spring. They have to deal with Social Security Administration claims and all that stuff. So they've got a lot on their plate. I have a full staff, and I'll talk about that, but I'm also blessed for the next 6 months to have Stephen Heiss, who we have claimed as the Texas Business Court International Fellow for Corporate Governance. Stephen just got his LLM from Harvard. He has a JD equivalent from a law school in Austria. He's this close to finishing his SJD dissertation on artificial intelligence and corporate governance. And he's going to start at Sullivan and Cromwell next year. He had some money left over from his Fulbright scholarship and wanted to come intern with me. He's telling me the entire world, business community, is looking at the Texas Business Court. Are we really going to fulfill our mission in providing the service? So this opinion, 81 pages, that had to go through the history of developing the nature of fiduciary relationships among partners, and through the statutory changes, and read the opinion. But it establishes, I think, the fundamental bedrock principle that we're going to enforce contracts the way that they're written, assuming that they're unambiguous, because it's important for the business people to have confidence that the business risk and allocations that they made in creating their contract in the first place are going to be enforced the way everybody agreed, not the way somebody wants it to be interpreted 5 years down the road when they don't like each other anymore. If we're going to have capital formation, we're going to have investments, we have to provide this form of predictability. So that was important. In the meantime, the judges' opinions have mostly been dealing with personal jurisdiction issues, subject matter jurisdiction issues. We are being successful in getting our jury trials and trial settings on the road. Our first jury trials are going to happen in Houston next month, unless they get settled. My first jury trial was going to be in November. Unfortunately, The plaintiff passed away, so that one is not going to happen. We are fulfilling the promise that the legislature and the governor and the people of Texas want us to do.
Thank you. Well, unfortunately for me, I heard you don't like discovery disputes and you don't like twisting the language of contracts, so I might be out of a job. But that does actually, Patty, I wanted to ask you a question about something the judge said about the business courts and how they might compare to business courts in other jurisdictions. And I know part of your job is helping clients all over the nation and have seen business courts in other jurisdictions. Could you maybe talk a little about what you've seen in that regard?
Sure, thank
Knowing
you.
the answer that ours are the best.
Yes, this is the best already. I'm just going to say that at the outset. So my role really here is to give a bird's eye view, because I work and we work, Concilio works nationally. So we have worked with business courts all over the country, and approximately 25 states have business courts already. And Delaware and New York are of the earliest. I think New York's was established in 1995, so about 30 years ago. And what have we seen from that so far? And actually what we've seen across those other business courts is exactly what Judge Whitehill is describing, and they're more efficient. They frown upon frivolous discovery disputes, so we see less of that. And as a result, things move faster, and you have judges who have more expertise in commercial disputes. Again, just as the judge described, in federal court and certainly other state courts, the docket can vary quite a bit. So if you can consolidate your business disputes in this court, you end up with judges who can create a body of case law that is more relevant and will help direct business disputes going forward. It doesn't mean, when we say this is pro-business, it doesn't mean corporations are going to win every time. You know, you may be on either side of the equation too, either party. But what it does is also, as you described, the case that had gone on for years in another court, it's a way to bring it forward to cut your litigation costs and your time so you can arrive at that decision faster. And also it encourages settlement through these increased efficiencies and having a judge that has experience in commercial disputes. So we've definitely seen that nationally.
And along that same line, Angela, I understand that your company is one of the first companies to adopt the forum selection clauses that I think have been now encouraged by recent legislation, selecting the business courts as a forum. Can you talk a little bit about the reason for that and how that's worked out?
Sure, and I'm going to make a caveat here that we happen to have a panel that's going to tend a little bit into securities and governance law with the exception of the judge, a securities and governance lawyer. Also a caveat that Southwest has pending litigation, a handful of derivative matters right now that implicate these issues. But with that said, factually, yes, Southwest made an amendment to its bylaws to add the Texas business courts as a forum for governance disputes. And I think for all of the reasons that Judge Whitehill talked about, and particularly to drive increased certainty. I know we'll probably talk a little bit about some of the other changes in the Texas Business Organizations Code, most notably SB 29. But SB 29 is also intended to drive greater certainty for Texas businesses when it comes to things like what are the requirements to bring a shareholder derivative action. And for me, and again, this is me speaking personally, not on behalf of the company or on behalf of the board, the idea behind SB 29 was backed with bipartisan support from the Texas legislature, and it was to make sure that Texas businesses have the opportunity to focus on issues that are important to the company. And the big way that gets accomplished is by putting in an ownership requirement, a threshold by which if a shareholder wants to bring a derivative action, you have to meet a pretty high ownership interest. The important thing about that is not to deny shareholders access to the courts, but to make sure that companies have the ability to focus time, effort, and resources on matters of significance to the company. And the underlying presumption and rationale behind that element of SB 29 is to make sure that, the larger shareholders and issues that are important to the board are the ones that get elevated in derivative proceedings. And so I think, again, while I can't speak on behalf of the board, that is what ought to motivate every company to consider whether or not to adopt some of the opportunities that are available in SB 29 when considering what that does for future litigation.
Yeah, thank you. Yeah, and those are obviously all issues that are facing all companies operating here. And maybe Andrew, I know your company is increasing their presence in North Texas. Can you maybe talk about that and maybe some of the reasons for that, and if it dovetails with any of the points that Angela was discussing?
Yeah, so Public Storage has basically split their corporate headquarters, so half in Glendale, which is right outside Hollywood in LA, and then half in Frisco now. I'm more of a beneficiary from that because I'm a recent hire, so I don't know all the historical background, but I can tell you that they're increasing their presence in Texas in large part for a lot of the reasons we've discussed. It's seen as a favorable area, and we are relocating a substantial number of our employees there and hiring directly in the Dallas area. And just kind of as one example, I have 5 open headcounts on my team right now, and we have some flexibility as to where we would fill those. And we are seeing a lot more applicants and qualified applicants in the Texas area. And that's kind of been a vindication of the board and our CEO's decision to make this move, because it's seen as not only a more business-friendly environment, but a place where you can attract talent. And speaking solely from a legal standpoint, Texas is just a much easier place to do business, generally speaking. I mean, when you're looking at the disclosures that you have to make when it comes to advertising, it's much clearer and easier to manage from a regulatory perspective. And then as basic as things as when you look at our metrics, how many AG matters we have, attorney generals from states, it is much less in Texas, and they're much less complicated. And going to even things such as state of emergencies where, for example, and this is publicly disclosed in our financial statements, we're dealing with a situation where for basically a year we're not able to raise rent in California due to this state of emergency from wildfires. Not that that's not warranted. I'm sure there's good policy behind that, but you see more of these extended restrictions on our ability to operate business normally in other states that you don't often see in Texas. So I can tell you it's a big push, and it's something that I think they wanted to do even before COVID, and they actually executed on it, and it's going quite well so far.
That's great. Yeah, and for the consistent theme that I heard through each of you talking about was the certainty on expenses and what the environment's going to be like and what the future is going to be like here, and that's again something that's great for all of us. Maybe Judge Whitehill, maybe jump back to you on sort of talking more about the future. What do you see, or are there specific plans for expansion of the role or coverage of cases of the business courts, geographically, substantively, or what do you see as the future there?
I see a great future for the business court. Geographically, I mentioned there are 11 divisions. 5 of us are currently operating. In this past session, prior to this past session, this enabling statute said if the other 6 are not activated by now, they were going to go away. The legislature saw that we are fulfilling our promise, and so they got rid of that sunset provision. I think we will see expansion into the oil patch areas where there's a lot of high-dollar litigation. A big chunk of the cases we're seeing already, particularly in the Houston area, are energy-related. Cases I'm seeing are energy or real estate-related. So we will see some activity doing that. This past legislative session, Montgomery County was not in the Houston division previously. Montgomery County, if you're not familiar with it, is where Exxon, Chevron, ConocoPhillips, a bunch of Fortune 500 companies are. So the legislature wanted to get them into an active division. That happened. There's a bill pending before the special session now to bring Bastrop into the Austin division. Why Bastrop? Well, that's where Tesla is. So there will continue to be expansion into areas where there is demand for our services. Like I said before, I see us like a business. We have a product, we have to provide a better product to meet your requirements, the consumers of our product. And as we continue to do that, we will see other divisions open up. Subject matter jurisdiction, the legislature passed some provisions that I think simply clarified what we always assumed was our deal. But for example, House Bill 40 made clear that if your arbitration dispute otherwise meets the jurisdictional requirements for business court case, you can bring your motion to compel, your motion to enforce, to confirm awards, those type of disputes. Trade secret cases, if you otherwise meet our jurisdictional requirements, I always thought we had them anyway. We always treated it as if we had them, but the legislature has made that clear. And so there are other areas where the legislature did that. I think we will continue to see expansions. One of the interesting areas that has already existed that has not been utilized, for example, in your trust disputes. Oftentimes a trustee is running a company and oftentimes has governance disputes. Through our supplemental jurisdiction, of course we can handle those disputes, but I believe we can handle many other disputes related to the trust as well. Our supplemental jurisdiction is sort of similar to federal jurisdiction with one huge distinction in that the parties right now have to agree for a supplemental jurisdiction claim to continue in the business court. Up until a couple months ago, that was not an issue. We're starting to see more plaintiffs, for some reason, don't want to be in a business court where the judges have the resources to pay attention to their cases, are trying to split that off. There was an effort in this past session to change that. At the last minute, that fell out. I think that in the future, that will change, and again, it will operate more closely aligned with the federal practice. We'll see.
One thing you mentioned that made me think of this, so cases can land in the business courts they can be filed there initially, they can be removed from state district court, and are you seeing different percentages of one versus the other, and are you seeing more use of form selection clauses that impact that?
Statistically, we're seeing slightly more original filings. We're seeing a lot of removal cases. In terms of business court specific form selection clauses, those really haven't had a chance to work their way into the system yet. I believe we will be seeing a lot more of those in your loan agreements. So we have an odd jurisdictional quirk with commercial loans. It has to be in the loan agreement, or the parties must later agree to bring it in. But a commercial bank can't just sue on a loan without an agreement in place to that effect. I think we will probably see that change over time. I'm not sure why the banks didn't want us to do that. But in any event, SB 29, I can't really comment on the policy of good policy or bad policy, but they opened up more opportunities to put in your governing documents. Yes. Business court form selection, jury trial waivers. In the Chancery Court in Delaware, it's a court of equity. You don't have jury trials. In Texas, by golly, we believe in jury trials so much that we put it in our Constitution twice. A lot of businesses don't have as much confidence in juries as some other folks, and so we've created more opportunities for businesses to put in enforceable jury trial waivers.
I have a quick question, and again for the judge. I know that the jurisdictional limit was recently lowered.
Yes.
Is there ever a thought, and again, not a suggestion, but a thought that it gets lowered even more? And the reason that I ask is that I think that for in-house lawyers who are considering venue when it comes to commercial agreements and form selection in commercial agreements, it can become sort of a more complicated clause because of the jurisdictional limits of the court. And so it's easier to just say, okay, venue in Dallas County, and then I'll have the option to remove in most of the cases if I want to. What are your thoughts on the jurisdictional limit?
Okay, so we have two buckets of subject matter jurisdiction. One are what I call the external disputes, which are going to be unrelated party contract disputes, and then the internal disputes, which are going to be derivative suits. They're going to be partnership disputes, governance disputes, those type of things. There's some overlap between those. But if you're relying strictly on the contract qualified transaction bucket, we started out with a $10 million amount of consideration involved and a $10 million amount in controversy. The legislature did that, it's my understanding, that they didn't want to inundate us right off the bat because we had to find office space. Believe it or not, there is not any place in the Dallas County Courthouse for a business court to operate. Best thing that ever happened. For any number of reasons. Well, I'm simply because it caused me to rethink how we're going to operate and do that. Personally, having spent a number of years, practiced my entire career in the Dallas County Courthouse and sitting on a bench there, I just don't want to be in that environment. I want to be in a different environment that is more comfortable, feels more like that. So they lowered it to $5 million, saying, all right, you guys now have your office space, you have your staff, you have your systems in place. We want more people to have an opportunity to take advantage of the business court, so they lowered that to $5 million. With the caveat that if you can digest that, well, maybe we'll go lower. If we are losing, and my concern is we're going to lose some of the magic that the business court is going to bring, which is my ability to be actively involved in managing cases, to be available to deal with stuff, to identify issues and deal with that, and to write opinions. I don't want to write, excuse my language, crap opinions. I want to write high-quality Court of Appeals or better type opinions because that's what the consumers want, that's what they deserve. So we'll see. But the legislature is open to either going up or back up some or back down. We'll just have to wait and see.
Yeah, and it's a purely selfish question because I can think of disputes that we've had that are less than $5 million but more than $1 million. That goodness, it would be nice to get the legal pure contract issue resolved and get it done with in less than a year. That wasn't a question.
Talk to your legislators.
So actually, Angela, maybe you can kick us off on this. You mentioned SB 29 earlier, but Andrew, Patty, I definitely welcome your thoughts on this as well. Could you talk a little bit about what SB 29 is, so everybody knows what we're talking about, and then what you're seeing for that and sort of the future of those issues?
Just that little tiny question,
Just that little tiny question.
To someone who's not a governance and securities lawyer. Thanks for that. We talked a little bit about it. So SB 29, I mentioned before the ownership threshold requirements. So publicly traded companies on a major exchange, which by the way is defined to include the Texas Stock Exchange, which I recently learned goes by Texi. And I'm thinking about Tesla and the models and how Elon Musk wanted to spell sexy, and I'm like, what a great synergy. Sorry, I digress. But the ownership threshold is something that anyone who falls within SB 29 can seriously consider the jury waiver. Although, we all have confidence and faith in the jury system, but for matters of corporate governance, it's a serious question to ask yourselves whether or not that's something that your company wants to entertain in its bylaws, the waiver of jury trial. There's a bunch of other business-friendly stuff that we all like to see, including not allowing for the request of things like text messages on books and records demands. But I think most people would say that the biggest is the codification of the business judgment rule. And again, not being a securities and governance lawyer, I'll give you my sort of take on what that means. And for me, it means that Texas wants to make it abundantly clear that while we have wildly successful businesses, those businesses and their leaders should be free to make bad decisions and to fail from time to time without worrying that the failure in and of itself or the bad judgment call is going to be repackaged into a fraud or a breach of fiduciary duty claim. And so again, going back to trying to drive certainty in what the
defense of claims against directors and officers looks like, having a codified presumption in favor of the business judgment rule really restates what Texas law already essentially was, but is incredibly helpful, particularly when it comes to giving senior leaders, executives, directors, and officers the ability to innovate and make decisions that they think are in the best interest of their companies.
I love that description. Thank you so much. And I really think, again, looking at it from a national perspective, that the addition of SB 29 and the business court, really what you've done, what you're doing here in Texas is creating a legal infrastructure that is business friendly. And it'll be both are brand new, and so it'll be really interesting to watch from a national perspective. You know, you seem to be giving Delaware a run for its money. So what results will come from this? What companies will now incorporate in Texas or re-domicile here or move, you know, half of their operations or headquarters? So I think this will be, you've created the infrastructure, and I think this will be really interesting to watch it unfold.
Andrew, have you guys talked about these issues internally?
So I'm a little jealous of Angela over here. We are we're structured as a REIT. We are publicly traded, and at least as of now, maybe this is an opportunity for Texas. There's substantial benefits to incorporating in Maryland, so we can't avail ourselves of the benefits yet. Although we do have ancillary entities, insurance, third-party property management, and some of those discussions are ongoing with the relocation. It's a lot more plausible and something that could make sense. So certainly going to the theme of certainty and kind of business friendly, it would certainly be something we'd consider. And hey, maybe one day Texas adopts the same things that Maryland has, and we can move the whole thing.
Got it.
Talk to your legislator.
It's probably coming. It's probably coming. AI. I think everybody's heard of that before. Judge Weiler, is that an issue that you all on the business courts have talked about, the use of AI, or and what the future of the use of AI might be in those courts?
We've discussed it, and we've dealt with it with the local rule that says use it all you want, but when you sign a pleading, you are representing to us that it's 100% accurate in terms of what you're telling us about the law. We have all heard stories of briefs coming into courts with absolutely made up citations. I have highly qualified staff, and they're going to be checking all that stuff. You know, I have not used it enough to have a meaningful comment on it. I understand it can be helpful in reviewing and editing and maybe helping with clarity and things like that. I believe that we will never be able to replace human intelligence, human reasonableness. Stefan tells me that the AI is getting really good at it, but I just believe that it's not going to be possible to completely replace human reasoning, thinking.
You know, I think it will be very interesting to see the decisions that come out of your court and other business courts related to AI. For those of us in the e-discovery world or who have participated in e-discovery disputes, we all remember when predictive coding came out, and Judge Peck issued those seminal decisions and allowed and endorsed the use of predictive coding. And it turns out that predictive coding was a way to reduce the data you looked at and get to those most relevant documents faster, and in fact had higher accuracy than human eyes. I don't know if any of you go back to the dark ages like I did when I started practicing law, and you had to go into conference rooms full of documents and bankers' boxes with sticky notes, and you'd look at them all. So certainly predictive coding just advanced that so much, saved money, and turned out to have a high level of accuracy. Okay, so now fast forward to AI. So I think that the world is also waiting to see what decisions related to AI, like who will be the Justice Peck of the AI decisions.
Yeah, I'm just waiting to see what the issues become.
Yeah.
And we'll deal with them. I don't know, it's too new.
It's too new. It's too new. Other than, you're right, these decisions have come out that have called out litigants on filing pleadings that have, you know, made up citations that weren't solidified, weren't
Yeah,
true.
so a little bit of background. I'm in a collaborative relationship with the SMU School of Law. Most of my hearings are happening on campus. When we get the law school renovation project done, I will be occupying the 3rd floor of what is now known as Carr Collins Hall, right smack dab in the middle of the campus. Fantastic. Fantastic for SMU, fantastic for the business corp. People are loving going to the law school campus. But what I'm hearing is law schools are going back to blue books because of concern that AI is going to replace, is going to be answering exams. And so it'll be interesting to see how that plays out.
Definitely, yeah.
Angela, are you, either of you using AI significantly in litigation management, like in-house? I know, I'm sure your outside counsel is using it to some degree, but.
I feel like I should plead the fifth, although I don't have to. I mean, I think in the same way that a lot of companies are doing things like, exploring how they can utilize AI in their legal departments to make what they do already more efficient.
Right.
I don't think we're using it in a way that would drive the substantive practice of law, but rather to look for ways to make things like our third-party subpoena process more efficient, look for ways to make our internal e-discovery tools more efficient, look for ways to help enable some of the routine work, but not so much with an eye toward trying to practice law with AI as a resource tool for the substance of the law. Certainly there are the issues of responsible deployment of AI within the business and from the consumer-facing side, but that could be a whole nother
Yes.
Yeah, I was just thinking on
topic.
the litigation management
Yeah,
side.
so a concern that has just really popped into my mind because it's just hit the street, if you will, is Westlaw has a new product, AI product, that summarizes cases for you. And
Yep.
my concern is people are going to rely on the summary instead of actually reading the cases. And what is that going to do? What impact is that going to have? It's super head note practice. We'll see. Sometimes that gets you in trouble. Yeah.
Kind of like the Cliffs Notes, where the teachers design the question towards the Cliffs Notes versus the entire text. And I suspect a lot of judges will trend toward that as well and might solve that problem.
Yeah. Again, I'll tell you, my staff, I have a full-time staff lawyer, a one-year term clerk that will rotate every year. They're high in their classes. Philip, my staff lawyer, was a Plan 2. If you're familiar with the University of Texas, that's their highest deal. He was a 3.95 biochemistry major with a double major in political science. 7-year associate at Gibson Dunn doing patent cases. And when I was doing presentations a year ago at large firms, I'd say, I'm sure this doesn't happen in your firm, but I know somewhere there's a 7-year associate that's disaffected and wants to do something different, and if you happen to know of anybody, send them my way. And that's how I got Philip. But we'll see, Trust that he is, and Kyler, my brand new term clerk, are going to be reading everything. They're going to be checking the cases. Don't do it. Don't get lazy. Do the work.
Thank you. About a couple minutes if anybody has any questions for the panel. Well, this has been great. I really appreciate hearing all your insights. And Judge, I just have to comment, one thing that particularly struck me is how you're talking about how you're operating your court and making the parties interact more and get involved and think about their cases. Because one of the things I've seen in 31 years I've been practicing here is what I always say is somewhat of a negative byproduct of how national our practice is becoming. It's fewer and fewer times when we know opposing counsel. When I started practicing law, we knew each other, we knew the judges, and those kind of things happen more naturally. And I think all those sort of processes are good because it's going to make it a more collaborative environment. It's going to drive the results more efficiently, allow outside lawyers to provide better results and more effectively and more cost effectively too. So that's great that you're doing that. Yeah.
One of the things that we're seeing, and will continue to develop certainly on a local basis, because many of the lawyers I see are coming from outside of the state as well,
Right.
because business in America happens nationwide. But we're seeing a group of firms and lawyers that are appearing on a frequent basis. And a lot of times in Dallas, in the commercial practice, you might not see another lawyer ever,
Right.
or it'll be years down the road. When I was doing fiduciary litigation for big trust departments, there was a small group of us that were in the same cases all the time, and that made the practice easier. We
Yep.
knew each other, we couldn't mess with each other. And I think we're going to see that develop in the business court with the firms, and the lawyers within those firms are going to be frequent flyers.
Yeah, that's great. Well, thank you again, and thank you all for having us.
Thank you, Nicole. I'm so happy to have you guys here on stage. I've got to be honest, when we started talking about subjects and topics, the Texas Stock Exchange was not necessarily top of mind. I didn't necessarily know that much about the stock exchange, so we're happy to have you guys here to talk about this and share with the audience what this is and everything and how it's going to impact the North Texas market and economy. Before I get started, let me go ahead and make some introductions of both you guys, and I brought my trusty notes here just to read these off. But Nicole, you bring 17 years of extensive experience collaborating with public and private companies across the U.S. Previously, you served as Senior Managing Director and Listings at NASDAQ, and in that capacity, you played a pivotal role in driving the growth and development of NASDAQ's listings and services and forming strategic partnerships throughout every stage of the capital market lifecycle. You're also an SMU alumni, which I am too, so go Ponies.
Yep.
Shane, you are serving as Deputy General Counsel of Texi and bring 30 years of the C-suite and executive leadership experience in the financial services industry with a deep understanding of the trading and processing systems. You hold a law degree from South Carolina and also an undergrad there in bachelor's degree in arts and sciences. And I also acknowledge that the Gamecocks are ranked number 11 in the AP Coaches Poll, so congratulations. But again, thank you guys for being here today. Like the first panel, if you guys have any questions, feel free to grab a mic. Don't hesitate to interrupt us. I anticipate that there's probably a lot of questions here that the audience is going to have, or you can save them for afterwards, so we should have time after the panel discussion as well. So we're here today to kind of talk about Y'all Street and Texi, and we heard a little bit about Y'all Street from the first panel, which garnered the nickname from kind of this burgeoning financial hub here in Texas. There's a lot of growth here, there's a lot of expansion and headquarters that are being moved to the North Texas market and generally Texas in general. We've seen the likes of Goldman Sachs, who's building a $500 million campus downtown. Scotiabank just announced moving here, expanding here. We've got Fidelity, Charles Schwab, Public Storage, and certainly the Texas Stock Exchange. So again, maybe just to kind of level set, because I don't necessarily know all the inner workings of how an exchange works. I'm sure there's probably others here as well. But Nicole, maybe you can help us understand, what is an exchange business model and what is the purpose and how these exchanges work.
Sure, we can tag team this.
Absolutely.
I'm not usually speaking with my lawyer next to me, so I have to be really careful.
And it's being recorded,
Yeah.
so it's even more exciting.
Thank you so
And
much
I would
for
say
having me.
normally, as an exchange, when you're a regulated entity, you give this long spiel about these are our own thoughts, not those of the exchange. But we're not approved yet. We will be shortly. So these are the opinions of the exchange as far as I can tell at this point. So with that, I'll let Nicole start.
No, absolutely. So if you think about it today in the complex market structure that we're in, companies, commodities, ETPs, they're being traded across ultimately 20 different exchanges. But really, as you think about it, there's only 2 exchanges that actually allow companies a conduit to the public markets, and that's through New York and NASDAQ. Both exchanges have been around for a considerable amount of time. New York, I think, is 250 some odd years old, and NASDAQ's around 70 at this point. So, we have certainly seen a very long history of a duopoly. But ultimately, if you think about an exchange business, it really comes from a few different areas. Number one, of course, from a corporate listings perspective, these listings pay a fee. But that's really not where any money is made, to be honest. The exchanges make a considerable amount of money off of issuers, off of the opening and closing auction. So if you are a company today listed on a public exchange in the US, ultimately their only obligation is to trade you at the open and at the close. Everything else throughout the day is in the open market and ultimately off your home market. But because there is an obligation to trade you at the open and at the close, there is certainly a monopolistic pricing structure that they've put in place to make a lot of trading revenue off of public companies. So, if you think about it, you might pay New York or NASDAQ $195,000 a year or $500,000 a year. And then on top of that, they're making millions of dollars off of these companies on a yearly basis, just off of the trading revenue. So trading revenue is a huge component of the business. The second piece is selling market data. As you can imagine, market data, especially in this day and age, is incredibly valuable, and that's a huge part of an exchange's business. Beyond that, I will say we've seen both New York and NASDAQ take a step away from maybe focusing on the corporate listings business and investing in and expanding their exchange business elsewhere. NASDAQ, as Zach mentioned, I was there 17 years, took a purposeful pivot to become a fintech company, ultimately acquiring different companies throughout the course of the last 10 years to really focus in the financial markets, less so on the listing side, but more so in the banking and financial areas that they can support technology. The New York Stock Exchange is owned by ICE. ICE has invested tremendously in their mortgage businesses. So if you think about it, the exchanges have had to diversify their business models to grow in different areas, but because they are the only two options, they never had to pour a lot of money into the listing space. Therefore, they can charge a large amount to list, they can add additional requirements and disclosures to you, and then make those dollars off of you at the auction volume. So I'll finish this comment and then change it to Shane, but ultimately today most companies trade away from their home exchange. You're usually traded on average about 20% of the day on your home exchange. The rest, 80%, is traded off, whether it's on BATS or FINRA or in dark pools or certainly off market. So if you think about it, the exchanges don't have a lot of work to necessarily have to do to keep up with the corporate side of the business because they can continue to raise the price at the auction and ultimately make more money or continue to grow in that respect.
And I always just like to ask this question. I apologize in advance. So how many people in the audience were even aware there were like 20 U.S. equity exchanges out there right now? And if I'll just say right now, I see like one other hand in the audience. That's not uncommon at all. Only people who are really heavily into the industry get that factoid, right? And that's because really it doesn't matter to the trading of a stock. The way that the national market system has been built is that anywhere you want to trade, connectivity has already been established, so a stock can trade anywhere. It's seamless to the end user, it's seamless to the company. But the companies are held hostage to that opening price and that closing price on their primary listing exchange. So because of that monopolistic moment in time at the open and the close, they see an extraordinary amount of volume occur at those moments in time. So when we talk about most of the trading volume during the course of the day trades away, but at the close in particular, because that's where you'll strike the NAV for a number of reasons, you will see a large amount of volume goes off on those exchanges on that single print for that closing price. So because they know they have that power, they charge up for it. And they don't explain that to their listing companies. The listing companies are basically told, you pay a listing fee, that's how we get paid for our services that we provide you. And trading's an entirely different thing. Don't look behind the curtain. You don't need to worry about that. That's trading mechanics. That's the back end stuff. Don't worry about it. And bluntly, we're here to try to help change that because we think transparency and exposure of a lot of this is going to be very beneficial because competition, quite honestly, is how you improve things.
Great. Thank you so much for that background. It's very helpful to understand. So these are exciting times for Texas, right? We heard a little bit about it on the first panel. We've got a lot of growth here and the financial impact that it has with the economy. But it's certainly good times for Texas. So how did this idea of Texas come up, and what are some of the goals that you guys are striving for, at least in the immediate future?
I will say the trademark of the Texas Stock Exchange has been around, on and off for the last 3 decades. So this is not a new concept, and neither are regional exchanges. If you think back, many years ago at this point, but there were regional exchanges in the Northwest and in Boston and in the, ultimately in this, what am I looking for?
Well, there was Arizona,
Arizona,
Chicago,
Philadelphia,
there was, yeah,
Chicago. I mean,
yeah.
I mean, clearly
Pacific Stock
every name.
Exchange, we could rattle them off. Now, all the regionals have either been gobbled up by the big 2 or 3 and or have shut down. So
Right.
they've mostly gone away. But the concept is tried and true.
Exactly, and the reason for regional exchanges back in the day was because you needed to be able to trade where you were based, right? If you were headquartered in Kansas City, you needed access to that local market. With the financial markets migrating to New York, many years ago, ultimately the duopoly acquired these markets and everything kind of just ran through New York. Well, it's funny because if you think about it now, ultimately finance has become incredibly decentralized. You can do work and you can run trades and you can ultimately be a company at any location in the world and still have access to the markets. And so now that finance especially has become decentralized, we've seen a huge migration and a push out of New York, a push out of New Jersey, a push out of Delaware for that matter. And ultimately, it's come to the center of the U.S., specifically the Southeast quadrant. Texas is, of course, leading in that state, but ultimately the Southeast quadrant that we're a part of has led population growth, has led GDP growth. We have had this incredibly pro-business environment that allows companies to run their business the way that they need to run them and not having additional red tape or regulation that requires them to have another person to answer to. So this has allowed Texas to, of course, become incredibly beneficial with headquarters moving here, as you mentioned. Corporate expansions. 1 in 10 public companies are based here. 55 of the Fortune 500 are headquartered here. We have more financial professionals in the state of Texas than in the state of New York. So we've really seen a shift out of New York for many reasons and into a very pro-business environment. What really got the Texas Stock Exchange kind of really moving and grooving was in 2021, the state of New Jersey, which is where the data centers live for the New York, NASDAQ, and many of the financial institutions, decided they were going to implement a transaction tax on any trade that occurred in any of their data centers. So ultimately, that was going to increase this cost for the exchanges and other financial institutions incredibly high. So they said, let's look elsewhere. Greg Abbott, Governor Abbott was, of course, part of that discussion and looking and showing New York and NASDAQ, and I was part of those conversations when I was at NASDAQ, which was, here's all the land, here's the infrastructure, here's how we can take you out of New York and into Texas and do it just as well. Ultimately, New Jersey figured out that would be a huge loss. They put their tax away, and ultimately they stayed, but it got the bug of, why are we trying to accommodate New York and Texas when we're doing some things really well here? And we have the opportunity to challenge the system that's been in place for 230 years and maybe bring an air of competition to it and choice that needs to be there. We certainly aren't here to necessarily put them out of business. I mean, that is a goal, but not today. But
Competition is always good.
I mean, I'm pretty competitive, but we'll get there. Ultimately, for us, it's how can we offer a choice, a different choice, an opportunity for corporates, whether you're currently listed today, better understanding how your trading works, the market structure works. What are you getting in return for how much they're making off of you? That is a great question. Is it additional disclosures? Is it your governance requirements? Who should be on your board? How you should be reporting it? How you should be disclosing it? It changes every year. New York and NASDAQ can file amendments that change their listing requirements and standards, and ultimately you have to abide by that. Otherwise, you're threatened to be delisted. We want to be predictable. We want to be business friendly, and we want to get out of the way. We believe an exchange should have a focus on making business easier to do. We want to be that conduit to the public markets to give you access to the best markets in the world. But we also need to say, you do you, let us go work for you. So let's work in state legislature. Let's work with the Texas business courts or other federal or SEC teams that can help us unwind some of the red tape that's been put out there over the last several years. So that's how we got here, and then I'll answer very briefly, how we're thinking about success here is, as Shane has mentioned, competition is incredibly healthy. We've already seen a response. with what we've been able to do just in the most recent session with our capital markets package that Shane will talk through, really immediately benefits companies. We're not even open for business, and yet we have been able to take pride in showcasing what we want to do, the advocacy efforts. We want to be able to do that, as I mentioned, whether it's at a state level or at a federal level. And, we certainly are hoping to reinvigorate a market that has been a bit complacent. We're at an all-time low of public companies, 45% decline since the mid-90s. 2.5 times that is backed by PE. So there's 12,000 PE-backed companies in the U.S. and 4,400 public companies. The ecosystem is incredibly out of balance. So what we are aiming to do is just give companies a choice that are equally as good. You should take private money, you can take public money, but we want it to both be an attractive option. Go public earlier. These companies that are going public at 20 billion, 30 billion, I think Klarna went yesterday at 32 billion market cap. That's a really difficult investment for a retail investor. We want to allow those companies to go public at maybe 900 million or $1 billion. We want them to access the public markets at an earlier stage for their benefit, but also to benefit the retail investor. So I'll stop there. There's a lot more we could get into.
I'm just going to make a point, and I think this is, again, maybe your history always influences your outlook, right? So I come from a trading background, and I've been in trading firms throughout my career. The trading side of the markets has been incredibly well serviced. So we say there are 20 U.S. exchanges. There's every pricing model you can possibly think of. We generally have what's known as a maker-taker model in the U.S. equity marketplace, which means if you are providing liquidity to the market, you are going to get a rebate for putting your lit quote out in the market, whether it's a buy or a sell. You get paid to do that. And then if you are going to take liquidity, you get charged for that. And the exchange makes a fraction on every one of those transactions, usually 0.3 cents or generally very much less than that, so 0.003, right? So that incredibly well-serviced market has had all of the exchanges focus for the last 25, 30 years. Listings has been ignored. And that is what we are actually now focusing on with laser focus and insight. So that shift is occurring because bluntly, we have brought that to the forefront, and now you see others maybe starting to make some rumblings, and that is in direct response to the fact that we have made these announcements and that we are coming to the market.
Shane, you and I were talking a little bit before the panel earlier today. And we've seen in Texas, and certainly in the North Texas market, a lot of startups, right? Texi is a startup. Talk about kind of how you guys got started from a funding perspective, because you were saying you guys are very well funded.
So, and again, I'll be somewhat cautious about it, but we are, and this is very public, the best funded Form 1. So when you file to become an exchange, you file a document with the SEC called a Form 1. So we are the most well-funded entity to ever file a Form 1 with the SEC. That is an incredible statement. I will say it again. We are the best funded entity to ever file a Form 1 with the SEC. I come from a startup background. I have been with many startups in my career. That is an incredible testament to the belief in what we are going to achieve, not what we can achieve, what we are going to achieve with the Texas Stock Exchange. We have an incredible investor base. It is not unintentional. We have the largest institutional investors. We have the largest retail trader investors. We have the largest market makers as investors. And we have listed companies as investors. This structure was intentional because as we go out to the marketplace, we are going to be calling on all of them to help support us as we go forward. And again, we are blessed to have that support. This is, again, was started with state belief and support, right? They wanted this to occur. There is not $1 of state money in the Texas Stock Exchange. It is a private endeavor, but it has very strong support from state, federal. The SEC is working very closely with us to get our Form 1 approved, and I would expect good news on that soon.
Great. No, appreciate it. Shane, turning to kind of the legal perspective, and you guys touched on it a little bit. There's been a long-standing duopoly between NYSE and NASDAQ, dominating the market for stock listings and trading volume. Given that we're here in a room full of attorneys, can you help us understand how this duopoly has really overreached their disclosures and reporting?
Sure. And again, this goes to what we've been talking about a little bit. So, look, the duopoly has been in a position of power, and so they haven't had to listen to their clients. The listing companies are their customers. This is a customer business. Judge, I was listening to you earlier. Judge said the business court has to serve its clients to be successful. An exchange, as much as they don't realize it sometimes, is a customer business. Our listing companies are our customers. Our member firms are our customers. We are in a customer business. You have to support your customers. So sometimes it is easy as an exchange. We are in a beneficial position. We have some very favorable positions when it comes to liability, et cetera. So exchanges are in an elevated spot. That does not mean you get to stop paying attention to your customers. You have to pay attention to your customers. So the duopoly has, I would say, not done as good a job at that as they could, and we are looking to make a change there. It's easy to point at a few things they've done. The easiest, and again, it's low-hanging fruit, so I'll hit the low-hanging fruit. So NASDAQ back in 2020 put forth, 21, the diversity rule. Now, the diversity rule, it's laudable to support diversity. It is laudable to support it across the organization. However, to enforce diversity with a rule at a listing company with very limited exceptions is challenging. And again, I'll go back to a personal anecdote because I love them. My brother was a member of a board of a small bank in South Carolina. I'm from South Carolina, although I am moving to the great state of Texas. The Bank of South Carolina delisted from NASDAQ because of all the burdens and regulations that NASDAQ put on them to be public, and they moved to the OTC markets. Now, the OTC markets is a great place to trade pink sheets and bulletin board stocks, and we can go into a long diatribe about what that means if you guys don't understand it. I'm happy to go off for an hour, Judge, as we do, as we love things. But that is not good for the market. It's not good for public disclosure. It's not good for retail, and it certainly isn't good for liquidity. We want to be there to help companies succeed and list on a national stock exchange. So that's where I think we end up there. Sorry.
Gotcha. Well, and you kind of touched on it, but in response to that, how is Texie going to make it more friendly for listing requirements,
Sure.
for reporting requirements?
I think the most, again, one of the challenges as a pre-launch entity, which whenever you do a change as an exchange, it is published. And we can tell by the way our competitors, which I'll quote one of our advisors, Chair Henserling, iron sharpens iron, I believe is what he said, which is a great quote. Competition's great, but because competition occurs quite in the public forum, anything we say that is delivered to this audience would then quickly be picked up by competitors. So we have a number of ideas. They are already in work and process of drafting. We can't share all of them, but one of the things we are doing and we want to continue to do is come to these events and listen to you. I mean, you guys are in the trenches. You know what makes it easier or harder to list a company with NASDAQ or NYSE, and tell us. We are ears wide open. That is part and parcel of what we want to be, because as a customer service organization, that is how you make yourself a better company. So we want to be better, we want to listen, and we are already stacking up ideas that, again, I think you will find quite intriguing and will lower some of those barriers to entry. We just have to be a little cautious before we are approved.
And I will add, if I may, this is going to be a high quality, high standards market. This is not OTC 2.0. Yes. We want to signal to the investment community, companies that list on the Texas Stock Exchange are growth oriented. They are truly here for the long term. They are going to be a strong investment opportunity. We are taking this as a chance to clean up what's not working in the market. If you think about the 4,400 companies listed today that I mentioned, 1,700 of them would not qualify under the standards that we're looking at. Those are companies trading under $1 for an exorbitant amount of time that have done multiple reverse stock splits. There are companies that are Chinese-based that are not following U.S. audit, and there are shell companies that are listed today that are distorting capital allocation and creating a negative investor sentiment. We believe there is a place for those companies, and it is the OTC. They should be able to go off of a normal public market, reevaluate, get stronger, and get back on a public market.
And I will point out, because it's a very important stat, that of those 1,700 companies, they represent something like 0.5% of the capital markets value. So it's not like this is a huge percentage of market value. It is just a large percentage of trading volume. And again, as we were talking earlier about trading volume drives a lot of profit for current exchanges, there might be a reason why they don't get rid of some of them, but there may not be. There may be other reasons.
And I think ultimately, going back to once we are approved and we can actually start talking about these specific requirements, it's going to be consistent. It's going to be predictable. This is not something that on October 1, we're going to be filing new and you have to change something for the following year. We really want to be predictable. We want to be able to be held accountable for what we're putting out there, because ultimately, as Shana said so well, listed companies are our customers, and having an unpredictable vendor or partner is a difficult person to work with, and we certainly don't want to be difficult in this situation.
It's actually a really interesting point, because as we think about how we set up our legal organizations, which I'm very highly responsible for, we also have a regulatory organization within the exchange. The regulatory surveillance part of the organization is extremely important to the functioning of a good national market, right? That regulatory arm does need to be separate from the business arm, and we are. But that doesn't mean that the regulatory arm has to be adverse to its clients. And that is, again, a mindset that we are bringing forth as part of the exchange. So our chief regulatory officer and I have been building out a lot of policies and procedures, both working with the SEC and then internally, and he has stated from day one, this is part of our goal is there's no hidden ball tricks. There's not a drawer that they pull out that they try to then figure out, oh, what was that memo that we created about that certain situation that then I know and nobody else knows, and I'll tell that one company and we don't tell that company, and it's different depending on what time of the week. No, that's not how you do these things. It has to be transparent, it has to be consistent, and it has to be understandable to all of our members.
And kind of diving into this just real quick, we all like to have a crystal ball to kind of forecast and predict out into the future, but with these listing strategies and these ideas that you guys are taking, how do you guys anticipate over the next 3 to 5 years, job creation, capital formation will take place, to the extent that you can forecast any of that?
I think becoming an exchange is not a quick business. So for us, the change is going to happen over time. And I think the benefit of having a lot of private investors is the longevity that we've been given and the ability to have a long runway. For us, we want to see, yes, when there's a healthy IPO market that's consistent, that's a job creating market. We want to have the opportunity to allow for new industries in the state of Texas, for example, to become more to the top. So for example, healthcare, biotech, it's not a huge industry right now in Texas. It's still very much owned by Boston or Silicon Valley or San Diego. We believe with the migration of money here, there's a chance for us to also continue to diversify the industry, and the fact that decision makers are here for those companies, we will continue to grow in different types of industry jobs. I also think that, that is another piece of it. Right now, if you're a public company, you have to get on a plane and you fly to New York to meet with that portfolio manager, or fly to LA, fly to London. we see Dallas as becoming a global financial center. It is coming along every single day. We're seeing things happen that are changing on a daily basis. But in 5-10 years from now, by 2030, I think this will be sitting right next to London, right next to New York, as far as this is where people come to have those important meetings, to have investment decisions made, and that only will grow the ecosystem around it, right? So absolutely, I think we will have a really big opportunity to capture as long as we keep the growth mindset that's done so well for us in this state, and we have the infrastructure to support it. I have no doubt that in 3 to 5, 10 years from now, you'll be talking about Dallas alongside Hong Kong and London and New York.
I think that's absolutely right. And again, it's the business forward, business centric, business friendly, not always business decision, right? Somebody said it earlier, right? Just when you go to business court doesn't mean a company wins, right? But it's consistent, it's fair, and it's known. Those are so important. I mean, uncertainty kills business. Uncertainty kills decision making. It's just, it locks things up. It locks capital up. Certainty frees capital. And Dallas is bringing certainty to all of this. And that is going to make this engine just grow and grow so that by the time we reach those milestones, I love, again, I'm moving here because I'm such a believer in this. We are going to see this be, not just on the same level as, New York and London. We're going to be better than that.
I'm excited. It's like a hype man right here. So this is
I
great.
just carry him around with me.
Yeah.
It's great.
You had mentioned that somewhere around 40%, there's been a 40% drop over the last 25 years of public companies. Given what Texi is doing, Nicole, maybe you can kind of share, what is your pitch to these companies? We've got a lot of employers here in the audience today, and what's your focus and how to bring in Texi to the market?
Sure. I think for us, everything we've said so far is kind of how we've developed our conversation with listed companies. I mean, I helped run the listings team, and I started a year ago before we even had a Form 1. The whole point, as Shane mentioned, was to have these conversations on what do you need from your exchange, and that's helped develop how we create this quote-unquote pitch. Our initial opportunity set, if you think about it, is going to come from currently traded companies, companies that we take off of the New York and off of NASDAQ and move over to the Texas Stock Exchange. We will launch IPOs, but we will do that probably 6 to 9 months after our initial trading of these equities that move over, as well as ETPs and the like. My conversation, especially if you think about it, there's a very large underserved market. Not everybody is Amazon. Not everybody is Tesla. The small to mid-cap companies, if you think about that, between $1 billion and $15 billion, $20 billion, so to say, they don't feel their voices heard. They feel like they are the ones taking the brunt of the cost. They don't have these huge budgets to operate. I think the stat we most recently heard is for ExxonMobil to be a public company, just the operating expenses is over $100 million a year. Obviously, that's Exxon. But you think about that at the scale of a company that's $2 billion, that's a lot of money. That's a lot of people. That's a lot of time. These companies truly have felt that they are the largest part of the market. They offer the largest growth opportunity, but they are the least heard and the least understood and the least considered. And I, having done, at this point, almost 18 years of it, that's true. You keep your biggest logos happy because if you lose that logo, that's a big loss. But you lose a company that nobody really knows about, well, meh, it's okay. I'll get another one. So I think that we've had the chance to really give a voice to companies that haven't had one in a very long time. Obviously, there's a lot of industries that are overregulated. If you think about a community bank or a utility or companies in the energy space, we can't necessarily unwind their industry regulation, but they certainly appreciate the fact that somebody is trying to work for them in another area that they're already having to answer to. So, the conversation is really collaborative. It's not just here's what we're offering and here's what we're doing for you and, take it or leave it. It's what can we do? If we think about the, opportunity and the potential money that we make off of a company in trading, maybe we think about that differently in how we give back to a company. Maybe we think about how we offer visibility and or quality trading. As Shane mentioned, our largest institutional backers are BlackRock, Citadel, and Charles Schwab. we have an opportunity to really think about how the market structures work for them and that we can maybe bring volume back to the home market versus having it constantly off market. So it is an iterative process as we talk to different companies and the type of company we speak to, but it is very much focused on whether you are a $1 billion market cap company or you're a $100 billion market cap company, we are treating you equally and the same, and both matter to us in that respect.
And are there any particular initiatives that you guys might have that you're able to share, whether active or planned, that the audience might be interested in?
Whatever we've shared publicly, I guess. Yeah.
You want to talk maybe about some of the capital markets package?
I mean, we certainly talk, and this is, it's been discussed earlier, so the capital markets package that was passed, so I don't think everyone knows, but so Texas Stock Exchange was heavily involved in that package. So from our CEO on down, we were engaged to get that package passed. We are firm believers that these changes are what will help make the economy of Texas succeed, and that's what helps the Texas Stock Exchange succeed. So we've been through most of it before, the codification of the business judgment rule, right? We've had that discussion already. I won't belabor the point, except to say I do think that this is really important in that, again, I've been on boards. I've been on other exchange boards. One of the first questions have had asked of me is, how much is your D&O? How much does your D&O cost? And what is your runway, because you're a startup or wherever you are, and I need to know how long it's going to last. D&O is incredibly expensive. We all know that. We think with this codification and with some runway, because it's not going to happen overnight, D&O insurance premiums in Texas will go down. And we think that alone will be enough to pay for our listing fees on the Texas Stock Exchange. That one change is that significant. We believe the change that I was talking about, the maker-taker structure a little while ago. So there is a constitutional amendment that was part of the package. This will codify that Texas will not institute a financial transaction tax. They will not impose this transaction fee. It's called a Tobin tax some places, securities transaction tax. It's called a stock transfer tax in New York. And actually in New York, they actually charge the stock transfer tax, but then they rebate it back to all the brokers, so it's kind of a flat thing. But you all know it's a heck of a lot easier to get rid of a tax rebate than it is to institute a new tax, so I would be a little nervous on pins and needles if I was in New York right now. But this will go to the voters, and if it passes, which we expect it will, this passed with overwhelming bipartisan majority in the House and the Senate. Constitutional amendment, Texas will never have a financial transaction tax. It's common sense. I actually studied this when I was at a prior firm that did research, and it only hurts the market. If you institute a financial transaction tax, it always comes with these huge, like, we're going to earn so much money, and it doesn't really do anything. It's a minor tax on those, evil, people who do trading. What it actually does is it drives volumes down, and it hurts the end investor. It really goes into people's 401ks is what it actually ends up hurting, because intermediaries, exchanges, brokers, they're really, really good at passing costs on down to the end user, and that's where it ends up hurting to the end retail investor. So it's a great move by Texas to get rid of that. We're codifying in Texas the franchise tax for exchanges for a recognized securities market in Texas only applies to total revenue. So again, this whole maker-taker and the tiny spread we're talking about, if you charge the franchise tax only on the revenue side of that equation in Texas, it would be devastating to the business model to any exchange that moved here. And again, competition's good. We already have another exchange here and active. We're coming in. Others might come. Great. We want to see a vibrant market in Texas. The more exchanges that come here, honestly, better it is, and whatever happens elsewhere, it happens elsewhere. But this helps provide a marketplace that an exchange can operate in. So the codification of that is extremely important. And then we've talked about the derivative lawsuit. So in Texas, you can choose in your governing documents to require for a derivative action that you have the shareholder proposal, for shareholder proposals, that you have to have a significant ownership stake. So you have to have a $1 million ownership stake or 3% of the market share. So that is really important. The SEC rule 14A8, I believe, requires $2,000. So, going from a $2,000 stake to be able to make that proposal to $1 million stake is significant. And again, we're not prohibiting it. We just want you to have skin in the game. You just don't want nuisance proposals because they are costly. And again, this is for the benefit of those in the room who have to deal with this as they come up. So those are kind of the suite. There's others, and we've talked about them, so I don't want to take up time and rehash everything, but I think those are really important.
That's great. So we do see a lot of startups here in Texas, and exchanges have high standards, whenever you IPO. And so how is Texi looking to make that more favorable for startups whenever they are looking to IPO, maybe at an earlier stage in their life?
Yep. So I think this is one of the trickiest questions because this is a balance. You can't lower standards to nothing, right? If you just take standards down and you let anybody in, you're creating like a secondary market. That's bad. That doesn't do anybody any good because you lower the standards and you have a junk market, then everybody else who's in that market is actually negatively impacted. So you have to keep reasonable standards. But what you can do is ensure that the glide path as you're working towards and with companies is clear, transparent, and understandable. And again, this is key. How do you do that? Well, your regulatory arm has to be very well functioning. They have to work easily with their client base. You have to have talented people who go out there and explain it to the prospective clients, and then you have to execute on that. There are other things you can do. We can look around, again, somewhat, I won't even call it around the edges. You can look at some of the tests that are performed, and we are looking at those to see, are there ways you can be creative and think, is there something you can look at versus, there's 3 years history that you look at currently kind of across the board for NASDAQ New York. And our current, I will say, when you're filing to become an exchange, there's what's known as copycat filings. It's just what it's known as. I think plagiarism is the sincerest form of flattery in the legal profession. You have no idea when it comes to regulatory work in the SEC. So for a Form 1 to be approved, the SEC doesn't want to see anything they haven't seen before. If it is different in any aspect, that becomes, novel. And if it is a novel issue, that is going to take a heck of a lot longer than 180 days. We need a 180-day approval because we have a business to run and launch. So our Form 1 filing is pretty bog standard. It is not, it doesn't, if you go to it, you're going to be like, you guys are talking about all these great things they're going to do, but if you read it, it kind of looks like other things I've seen before. Yes, it does, but as soon as we get approval, and the SEC well knows this is coming, we have a laundry list of this and this and this. Now we have to be a little careful about it because if we get approved and then day 2 we file 50 filings, they are not going to be happy with us. So we do have to work with them, and we're very much in communication, and they know we have a lot coming, and we are going to appropriately stage that with them as we go through. But things like the earnings test, and how do you approach that in a way that will help earlier stage companies think differently about it.
And so it sounds like you're already in process of either discussing with the SEC or so on, but how do you safeguard institutional investors with these younger IPO companies?
And again, you have to remember what is the role of an exchange, because this is kind of really important. An exchange does not call winners, right? An exchange sets the rules. An exchange makes sure that they are run fairly and they are managed properly. But we don't call winners. We are not the market. The market is the market. Now, if a company then fails to maintain those standards, it is incumbent on the exchange to take action. And that is what Nicole was talking about with some of maybe our competitors not doing so much of that because there's so much volume being run through some of these maybe not so great companies that it's hard for them to pull the trigger. We think it's really important when the companies are not succeeding to make sure you take the appropriate action. At the same time, you do need to be able to work with companies to ensure they understand what are their rights and obligations so that it's not a surprise, right? Should never be like a, hey, you're getting delisted, sorry. There should be a very open communication path. So that's one. But if they fail, they fail. That is just kind of the nature of the markets. We don't call a winner. It would be great if you could create a market that said every next trade is higher, but nobody would trade in that marketplace.
So we do have a lot of companies that do work internationally, right? And so could you help us kind of understand how the General Counsel's office is advising clients, from a regulatory standpoint, as they continue to expand or grow internationally? How would you guys advise them, and how does that look from y'all's perspective?
Move all your companies to Texas? I mean, I guess it really, where are you wanting to focus on that?
Yeah, I just think that, with respect to, these folks that might want to come enlist, here in Texas, how would that affect them?
I think a couple things, and then obviously, Shane, please weigh in. I think a couple things. Number one, the state of Texas has this mentality of we want to win. That's a very unique piece of why I think we've been so successful. Is it's a community idea that we are going to win as a state. And I think that has come, politics aside, of course, from our leadership. And I have met with more foreign companies than I have in my entire career at NASDAQ because of the Texas Stock Exchange. Governor Abbott's office is turning them around as quickly as possible to us. Taiwan, for example, is building a huge plant in North Texas that'll, I think, employ 80,000 people, if I'm not mistaken, at some point. They have incentive to be partners in Texas. So they want to have a pipeline on how can we look at expanding our business here. If we list here, what do we do? We see companies on the London Stock Exchange. The LSE has not been doing particularly well. There's not a lot of investment opportunity and liquidity offered there. Those companies are considering, whether it's Shell or BP, again, this has been all publicly stated, maybe we drop that listing and solely list in the US. And as we look at that, who's more energy friendly than a Texas exchange? We certainly are here to be an industry-specific exchange. We're agnostic to industry, but we have that mentality of if you want to bring and grow your business in the U.S., come to the most friendly and accessible door you can. You shouldn't have to know somebody on Wall Street to do business on Wall Street. You should be able to do business in the state and in the locations that your people are located or the talent that you're sourcing is, and then also list there as well. So I will say that it has been overwhelming, the companies we're speaking to outside of the U.S. that want to come in here and that maybe never really considered it because it just looked too difficult or too daunting.
And it's actually an interesting point on people. So, and this isn't always the case, but again, I'll just do the anecdote thing. So, I started in a company that was based in Charleston, South Carolina, like 30 some years ago, financial industry. We were the only company in Charleston, South Carolina that did anything in the financial services. And we would hire globally, and we would hire from Wall Street. And when we called up and said, hey, we'd like you to move to this little town in Charleston, South Carolina, they'd go, you're out of your mind. Why would I move to Charleston? If it doesn't work at ATD, I have no prospects. There's nowhere for me to go, and then I have to move back to wherever I'm coming from. Dallas is a very different story, right? Dallas has all those financial professionals, and with all the supporting network and all the other industry that is here. So it's not just financial services, it's industry. It is the infrastructure. It is everything that companies need to come in and be successful, and that is what's so incredible.
Got it. And as we begin to start wrapping up our discussion, maybe you guys can give us a little bit more details, if you're able to, on the timelines and when you guys kind of see things taking shape.
Sure. We are, as we've said before, very excited and eager and working with the SEC on our potential approval of our Form 1 here in the next few weeks. So that is certainly a huge milestone win for us. The expectation is that we will open our purpose-built trading platform in mid-Q1 of 2026. That will allow us to be part of the national exchange system. So another option for companies to be traded on and investors to trade on as well. That will then allow us to launch into listing listings of ETPs. So exchange-traded products represent a multi-trillion-dollar industry by 2030 and will be a huge growth engine for the Texas Stock Exchange, as it is already for CBOE, New York, and NASDAQ.
And I believe ETPs just recently overtook the number of listings of ETPs are now higher
Yes.
than the number of corporates
Yes.
in the U.S.
And it's a tremendous, not only opportunity from an exchange perspective, but for, the broader investment community. So we're excited that that will be our first entrance into any sort of listing. By mid Q3, early Q4 of 26, we will then start the corporate listing side of things. So that's when you will start to see announcements of companies that are transferring off of their current exchange and onto the Texas Stock Exchange. We will, by hopefully early 27, mid 27, have our Texas Market Center built. We are currently evaluating where in North Texas, obviously most likely in close to downtown Dallas, where we should have our physical location. We not only are going to be a tremendous electronic trading platform, we want to have the emotionality of an exchange. We want to have people be able to come and, ring a bell, shoot a cannon, shoot a gun, drive a bull. I mean, whatever it's going to be, we'll figure that out. But we want to have.
You hear her say shoot a cannon and laugh.
Don't
laugh.
underestimate. It might be a cannon. I think that you can deal with that insurance claim.
We're trying to figure out the pyrotechnic claims in the city,
But we want to have a location for companies to celebrate, and that will be important for IPOs, right? It's really going to be hard to win an IPO if you can't celebrate them. That's a huge milestone in their business. And so for us, IPOs, as I mentioned earlier, will come a little bit after we start corporate listings. That Texas Market Center will have event space. It will have visibility in a studio. We'll have a Texas Business Museum. We will showcase everything from the spindle top to the Gigafactory. There's a tremendous amount of inventions and ideas that have come out of the state that have changed the world. And we really want to highlight those fantastic ideas, those business leaders, and have that as a constant change in what's happening now in our community. We say Dallas because obviously we're headquartered here. We think all boats come in with this tide that we are part of. We are certainly not the ones bringing the tide in, but it's going to be beneficial for Houston and Austin and the Southeast Quadrant, and then obviously beyond. So those are our most immediate milestones to meet. But as I said, our longer term goals are to really change the capital markets and this be a huge historical event.
And where are you guys physically located?
Right now, we are in our temporary location over at Knox and Travis. So we're in that Weir Plaza building, subleasing a floor from an investor of ours. And it's beautiful.
Beautiful.
Come on over.
I will say, so I've been able to go to the office space a couple of times now. It's knockout. I've built out a few offices over my career, and this is top notch.
Very
so
Texas-like.
for subleasing space, it is the best sublease space I've ever been in.
Yeah, so we're just temporarily there while we locate our forever home.
Our market center will be world class.
Yes.
It will be rivaling NASDAQ NYSE. You will not, when a IPO or a corporate comes to ring our bell, shoot our cannon, they will feel every bit of pride that they would if they were doing it anywhere else, and more so because it'll be Texas.
And I think, what the exciting part it is for Dallas, and I'm assuming most people in here are from Dallas, if not, sorry. It's going to be an actual, as I said, on the global scale, right? You have a dignitary come into the state of Texas to meet with Governor Abbott. He wants to bring them to the Texas Stock Exchange and show them off what we've built here. We have an opportunity. Obviously, Austin is always going to be where government is living, and we certainly don't want to mix the two, but Dallas is only going to allow that global scale to be seen because we have such a preeminent market center.
Perfect.
Absolutely.
I think that's all the questions that I've got for myself, but certainly want to turn it over to the audience. And I was instructed a long time ago that when I ask if there's any questions remaining, to allow 8 seconds until somebody comes up to the microphone. So I'll give you a few seconds to come up if anybody is interested. And while they're doing that, if somebody is interested in Texi and listing and changing over, how do they get in touch with you guys? What should they do?
I'll give you my home address. They can come sit with me right now. No, that's exactly what I want to say is we're here. Sincerely, we want to hear from you. We want to talk to you. What's not working? What is working? How can we make sure that as we come to launch that we're coming as the best possible choice and the best possible partner? We see this as a partnership. We want to be able to have these conversations. So by all means, even if you have no anticipation of changing, give me a shot, but also
Yeah.
let me hear what you
But
think
we
about
want to
all
hear the
this.
concerns, even if you
Yes.
don't necessarily want to come to the Texas Stock Exchange, we want to know what your concerns
Yes.
are, because we want to build the best stock exchange in Texas possible, and then eventually you'd want to come anyway.
Yeah.
If you want to reach us, I would say you can reach out to us on LinkedIn. Say you saw us at the ACC, so I know you're not spam and you're not a robot, and that'll help us filter a little bit, because I will say, I'm sure you get I can't imagine how many you get. I'm like the lawyer guy, and I'm getting inundated with these, like, I have to scroll through. So, but just say you were at the ACC conference,
Yeah.
and we'll accept and create a conversation. I'd love to further it with any one of you. So this was wonderful, and wanted to thank ACC. I want to thank Celia for having us. This is a fabulous opportunity. Thank you all.
Well, that 8 seconds has expired. I don't see anybody with a microphone, so thank you all. Enjoy the rest of your afternoon and event.